Hello everyone, my name is Joe Esquivel, and on behalf of U.S. Equity Initiative Private Member Association, I welcome you to today's webinar, the Investigation and Chain of Title Analysis Review. With that being said, let's get started. First off, our disclaimer. Legal information is not the same as legal advice. This site provides entertainment and educational information about law designed to help users safely cope with their own legal needs. But legal educational information is not the same as legal advice. The application of law varies within individual specific circumstances. The laws of every state are in constant change, and although we go to great lengths to make sure that our information is accurate and useful, we recommend that you consult with a lawyer if you want professional assurance that our information and that your interpretation of it is appropriate to your particular situation. The reason for the webinar is that we have been asked many times, how is it that you are able to come up with this information? What steps or processes do you go through in your investigation to come to a determination and a conclusion of the findings that you are giving us? So today, we are going to go in depth and look at an investigation as to the steps that are required to take. So part one is the investigation. 1. All of these chain of title analysis are done by a licensed private investigator. We are licensed through Texas Department of Public Safety. If you care to see the status of any of the investigators, you are free to go to this website and take a look. We are going to go through this investigation as one would peel an onion. An onion is in layers. As such, your mortgage loan is done in layers. So we are going to go through this layer at a time. The first layer consists of elements of a mortgage loan. Among these elements, we have chattel paper documents and intangible documents. Let's start with the tangible promissory note. What is a tangible promissory note? Well, a tangible promissory note is a piece of paper that can be touched, that contains the promise to pay, but the real significance is not the physical paper, but the legal rights which the paper confers. And hence, the paper tangible promissory note is defined by the legal debt. I promise to pay. That is the legal debt. The note is a tangible negotiable instrument that evidences the intangible obligation. It is governed by the Uniform Commercial Code Article 3 or your state's equivalent thereof, pertaining to negotiable instruments. Promissory note intangible, or an E-note. Okay, an E-note, all right, is an electronic transferable record that is created during securitization and signed in accordance with e-sign that commits the maker, which is the account debtor or the intangible obligor, to pay a specified sum on demand in accordance with a contract that is not governed by the Uniform Commercial Code Article 3 or your state's thereof equivalents to an intangible obligee. Transferable records are governed by Uniform Commercial Code Article 8 or your state's equivalents thereof. Security interest. This is the intangible to the UCC Article 8 note, or the E-note. E-notes are created electronically, stored electronically, transferred electronically. Again, they're electronic. They're not material. They're not tangible. The security interest, which is the intangible, meaning you can't touch it, to the UCC Article 8 note is the intangible obligations that are created during securitization by an account debtor, which would routinely fall under UCC 9-102C, are routinely swapped for another intangible obligation, meaning certificates. As such, being a transferable record, such transaction would fall under the governance of UCC 8. For this certificate intangible to be secured by intangible account debtor's personal property, because it's not real property, the negotiation of the intangible obligation must be in compliance with UCC 8 as it applies to transferable records. As to the personal property securing the transferable record, UCC 9 would provide governing law because it's personal, it's not real property. Now, I know you're getting a little bit confused when we talk about obligations being routinely swapped for another obligation being the certificates. If one were to actually read a pooling and servicing agreement or a 424B5 prospectus, it talks about swap certificates. And many times when you read it, it mentions it again and again and again. If you further read, it also states the sponsor shall own no assets. Well, wait a minute. How are they doing all these transactions? The depositor shall own no assets. And I know you're asking, Joe, how is that possible? Well, you need to understand that in order for this to be a REMIC, Real Estate Investment Mortgage Conduit, or an RMBS, Real Estate Mortgage-Backed Security, there must be a minimum of 2 arm's-length sale transactions. Because this must be bankruptcy remote pursuant to the SEC and pursuant to IRS standards. IRS standards would fall under Title 26. So let's continue. Okay, let's talk about the tangible security instrument. What is that? Tangible security instrument means a writing in tangible form to memorialize the obligor's or debtor's pledging of an asset or property as an alternate method to secure payment to a tangible obligation, if in accordance with all applicable laws of local jurisdiction. It is governed by local laws of jurisdiction in which the real property resides. Now, examples of these would be either a mortgage, a deed of trust, or a security deed if you were in the state of Georgia. All right, let's go to another layer of this onion. Land records. What are land records? Well, land records are documents of transactions that are being claimed that have been recorded into public record, thus giving constructive notice to the world. In order to give constructive notice to the world, one needs to file this into public record so that everyone may see this. Examples would be an assignment of mortgage, an assignment of deed of trust, a substitution of trustee, warranty, grant, bargain, or sale deed. Again, depending on your particular state and the county that you're in, you may have a different name: warranty deed, grant deed, quitclaim deed. Or you may have a notice of default. Again, these are just documents of transactions that they record into public record, giving constructive notice to the world to say, hey, look at me, I've been filed. I'm laying a claim. Layer 3, statutes and law. Now, within the investigation, there's many different types of laws and codes we need to look at. We need to look at United States Code. We need to look at federal law. We need to look at Uniform Commercial Code. We need to look at state laws. We need to look at local laws of jurisdiction. All of these go into elements of a mortgage loan. Depending on your particular situation, the documents you've been provided with and you provide us with makes a determination as to what can or cannot be looked at for your particular situation. Next, many of you are asking, well, Joe, what should have happened? Well, depending if you're with a mortgage-backed security or a government-sponsored enterprise, would make a determination as to the events that were to happen. If you are in a RMBS, residential mortgage-backed security, that is traded publicly, all right, there are many transactions that were to take place. It can be anywhere from 2 to 3 to 4 to 5. What you need to understand is that the transactions pertaining to the note, being a negotiable instrument, and the transactions pertaining to being recorded into public record need to travel on a parallel course. So you would have two lines, and negotiation, transfer, and delivery of the note would match with an assignment being filed into public record, giving constructive notice to the world of a sale and the acquiring of rights. When you're filing into public record, you're saying, look, a transaction has occurred. Look at this. For example, the first sale, all right, from party A to party B, along with the first assignment, with party A releasing its security interest in the security instrument and assigning the interest to party B and recording this transaction into public record. So we would have an endorsement from the lender to, say, for an example, a sponsor or a seller. And at the same time, they would, of this negotiation, sale, delivery of the note, as well as the intangible obligation, all right, they would do an assignment of mortgage or deed of trust or security deed, where they would release their interest in this instrument being their personal property, and they would assign it from party A to party B. Upon filing it into public record, where it is filed, indexed, and recorded, there would be a proper perfection of this lien. The security instrument would attach itself to the obligation, which is evidenced by the tangible promissory note. Let's say party B now decided to sell to party C. All right, so we would have a second sale from party B to party C, along with an assignment with party B releasing its security interest in the security instrument and assigning the interest that it had to party C, and then recording this transaction into public record, where it is filed, indexed, and recorded, thus giving constructive notice to the world. Again, it would go from party to party to party. So depending upon how many transactions were to be done pursuant to the governing documents, you could have 2, 3, 4, 5. Again, for every transaction pertaining to the negotiable instrument, you would have a parallel transaction pertaining to recordation into public record. So for every sale, transfer, delivery through negotiation, an endorsement, and delivery of the note, you would have an assignment filed into public record. Okay, now once we've gone through all of that, now we need to compare all of the documents and records being of both tangible and intangible to the statutory requirements of law pertaining to the sale of the entire mortgage loan instrument, consisting of the tangible promissory note, a tangible security instrument, securing the indebtedness, which is the obligation, which is a promise to pay. Now, the security instrument attaches itself to the obligation, which is I promise to pay, your promise, which is evidenced by the tangible promissory note. And we look at all of these. We look at what does the law say? What do the statutes say? What do local laws of jurisdiction say? What does the pooling servicing agreement say? What does the trust agreement say? We need to look at that. So it means going through piles and piles of documents. And yes, sometimes we have paper documents, and sometimes we don't have paper. We have electronic documents. But I will share this with you. There is a heck of a lot of information that we need to cipher through. A heck of a lot of information. Some of these examples are pooling and servicing agreements, 424B5 prospectuses, free writing prospectuses, trust agreements, circular supplements, selling guides, custodian manuals, Freddie Mac document custody procedures, custodial agreements for Fannie Mae, and many, many more. And they are not all the same. Every one is different. So when we're looking at them, here's an example of one. This is a prospectus supplement. And when we go through it, what you see, I've just happened to highlight in yellow so you can have it jump out at you. This shows you we're not making up this information. We don't just pull it out of willy-nilly. This one, it tells the date. It's a supplement to this prospectus. Who is the sponsor and seller? What is the name of the trust? And here it says, the issuing entity will issue 81 classes of certificates, 75 of which are offered pursuant to the prospectus supplement. So they're going to have 75 classes which they are offering to the public. We go further through it. This is the information that goes into your analysis. Talks about the mortgage pool, reports, events, default, the trustee. All this information is gleaned out of here. The name of the trust. Within your analysis, I talk about it's governed by New York law or Delaware law or whatever state it's from. It says here, a common law trust for this particular entity under the laws of the state of New York. Why is that important? Well, because New York has specific laws pertaining to trusts that are set up in its state. We talk about the depositor, the sponsor seller. All this information, the trustee, the NIM insurer, the closing date, the cutoff date. So this is where all of the information is gleaned from. Again, this one, there's only 346 pages. A free writing prospectus can have 1,200 pages. So it's a lot of information to go through. Again, this pertains to a residential mortgage-backed security. When we go to GSEs, which are government-sponsored enterprise, we look at different documents. I've got a Fannie Mae, requirements for document custodians. Again, within this document, there's only 51 pages, but it tells me everything that I need to know for Fannie Mae docs. What does the custodian need to do? This is where the information is cleaned from. I've gone through and I've printed out all of these manuals, hard copy, read them, tabbed them, highlighted them. This one is a Freddie Mac document custody. So it just depends, but all of the endorsement assignments, it talks about endorsements, lost note affidavit, compliance and controls. This one is for Ginnie Mae. So we've got lots and lots of material that we glean. It just pertains to your specific situation. All right, we also have trust agreements. Many times there is not a pool and servicing agreement. There's a trust agreement. For this one, Fannie Mae, it says RMIC Master Trust Agreement. So these are just some of the documents that we go through, just to give you a heads up. All right, continuing. Oops, I apologize. We went backwards, folks. Let's just continue. There we go. We compared them. We looked at the docs. There we go. One more time. What did happen? We talked about that. All right. The question comes up, what did not happen or not take place according to statutory requirements of law, as well as the government documents that were required in order for true sales to take place? This is the question that I ask, and then I go and I review all the statutes, I review all the documents, and I say, okay, this didn't take place, this didn't take place. What was to take place? And we compare them, and then we tell you, okay, here's what was to take place, Joe, and here's what did not take place. In regards to one of the questions, it is, what are the requirements that were violated in regards to keeping tax status as a RMIC? Well, when we look at many times a prospectus supplement, and I go to prohibited transactions, because there are specific guidelines under IRS in regards to assets being put into the trust. You can go to IRS Title 26, 860, D as in Delta, which talks about a RMIC is not a RMIC until all the assets have been put into there. And yet, many times when we look at these RMICs, these trusts, there's assignments that are done 5 years later, 10 years later, 8 years later. Well, wait a minute. If it said that all of these assets were to be put into the trust, why are you trying to do it now, 5 years later, 8 years later? Have you lied to IRS? Or have you lied to the courts? Or have you lied to the homeowner? Or have you lied to everyone? The majority of the time, the timing requirements have not been met, folks. They have not. I then take all of these conclusions and we put those findings into a concise package. Depending upon what we found, your circumstances, whether it was a government-sponsored enterprise it was put into, an RMBS, a private investor, would make a determination as to the end result. So, your chain of title analysis that we complete, right, may or may not have an infographic. An infographic is a visual representation of transactions that were to take place or that did not take place depending upon your specific situation. About 80% of the time we are able to do an infographic. Again, these are copyrighted infographics. They've taken months to create. And because of the many, many different scenarios and because of the documentation that I may or may not have, we may or may not be able to provide you with one. And I get asked, well, Joe, can you make me a special one? Yes. If you got about $2,500 you'd like me to do, I can make you a special one because of the time and the effort that's involved in doing the research and getting the information and sitting down and building your own. It can cost $2,500, $3,000. These took about 6 months to put together. And that's after years of understanding and reading and understanding and reading and understanding and not understanding and going back and then understanding again. And then going through the process of getting certain documents, Fannie Mae documents, Ginnie Mae documents, because all of the information that is on these infographics can be backed up factually, every single one of them. So if I tell you that pursuant to Fannie Mae publication, whatever it is, and it says it on this infographic, I have that infographic to back up that particular page and paragraph that is cited. Here's an example of an RMBS loan securitization diagram. On the left side, it talks about what was required pursuant to statutes and trust documents. And on the right side, it talks about what has actually happened. They look entirely different. On the left side, we have Jane Doe as the borrower. Jane Doe signed a Doe note and a Doe mortgage. When signing at the same time, there was a temporary perfection. By taking this Doe mortgage and the lender sending it to the county recorder's office, a permanent perfection was achieved. When they sent the Doe mortgage to the county recorder's office where it was filed, indexed, and recorded, and then sent back to the lender, all right, there was a perfection was achieved. They've given constructive notice to the world. Hey, look, it's been recorded. I own the note. I have it. I've got the obligation. Now, the originator decided to have a sale, and he sold it to the sponsor seller, New Century Credit Corporation. So through endorsement, negotiation, transfer, and delivery of the note and the intangible obligation, it was sold. At the same time, there was an assignment of mortgage created where the originator released its beneficial interest and assigned that interest to the sponsor seller, and it then recorded that at the county recorder's office where it was indexed, filed, and recorded, thus giving constructive notice to the world. So we went from the originator to the sponsor seller to the depositor who did the same thing down to the trustee. So for every transaction of the note and the intangible obligation, there was an assignment filed into public record. So you notice that the Doe note and the intangible obligation, which is within that Doe note, has stayed there. So when we get all the way down to the bottom where this went into the trust, now, the closing date for the trust was August 17th of 2005. Jane Doe closed July 6th of 2005. So they had 1 week and 11 days in which to do all of these transactions, get them recorded into public record, and get them back and get them recorded and get them back and get them recorded, but they did it because that's what was required by statutory requirements of law and the governing documents. Now let's take a look at what actually happened, folks. Turn your attention to the right side. We have the borrower, Jane Doe, and yes, Jane Doe signed a note and a Doe mortgage. They then took that mortgage, they filed it at the county recorder's office where it was perfected, recorded, indexed, and was filed. It was sent back to the original lender. All right. And at that, it stopped. And when it stopped, all right, within 24 to 48 hours after it came back, the original lender took that note and scanned it into their system. And they stamped on that note with a payee as of yet unnamed. And then they either destroyed it or they put it into a vault and they lost it. Because many times they don't want the original note out there. They want their copy of the note. Now, they decided to do a sale. All right? So, what did they sell is $1 million question. Well, they've stripped out the payment and tangible obligation, which you see as this little square here. and the originator sold to the sponsor seller, which is New Century Credit Corporation, who then sold that payment intangible obligation to the depositor, who then sold that intangible obligation to the trustee, who then took that and then put that into the trust. But the whole time, the DOE note, they don't know what happened to it. They can't find it. Well, we got a copy. That's good enough. And the DOE mortgage, once it left the county recorder's office up here, it never made it back there. There were no assignments made, okay, on record to memorialize any transactions of any sale. But yet years later, assignments are done. That's what these X's are, assignments that are made, and they're referenced within the analysis. The X shows that that can't happen. Those documents were not eligible to be recorded. They were ineligible to be recorded. Again, your particular loan may or may not may or may not look like this. It can look completely different. Again, we've got many, many different charts. So it just depends upon your particular situation. All right. Within that chain of title analysis educational package, we do have information on endorsements. And the reason is just to give you examples so you don't get fooled. We talk about what is a blank endorsement. What is a restrictive endorsement? What is a special endorsement? So we give you a lot of information. So right now what we're going to do without further ado is to go through an actual chain of title analysis for your review. Now I'm going to use a John Doe sample. It is an actual analysis. However, what I'm going to do is use John Doe's name in there. So no one's going to see their name. Again, it's an actual analysis. However, we've just replaced John Doe. So with that being said, here we go. All right. On this particular instance, we have, this is the cover page for John Doe. Again, yours will be different. It says here prepared by mortgage compliance investigators. All right. We are the investigators. I'm the gentleman that's putting my name on this. This is the address. This is our building, the suite number. This is my license number. This is license number for the company. Now, I ask you to take a look at the table of contents because a lot of time was put into this. A lot of time was put into this. So when you look at the different sections, section 1, intro to conveyance of a securitized mortgage loan. And we go through it, elements of a mortgage loan. What got securitized? Personal property, real property. What should have happened? What did happen? Conveyance of an e-note. You go into section 2, which talks about your mortgage loan transaction history. And it has your unique mortgage loan details. It has your unique securitization details. Section 3, we talk about the infographics. Now, you may or may not have an infographic, so it just depends. Section 4 is, we talk about New York trust law, information on endorsements. Section 5, we've got supporting documents depending on what we found, trust agreements, pool and servicing agreements, 424B5 prospectuses, circular supplements. So, as we go through this, this will give you a little bit of what to expect. Again, I would encourage you to go get a cup of coffee, a glass of wine, And you're going to take probably a couple of hours the first time you go through this. I know many of you, you're going to say, I'm just going to get an idea of what they're saying. Well, you know what? You're going to have to read this probably 2 or 3 times. And I know that because I've given this to attorneys for opposing counsel when I'm in court testifying. And I've had more than one tell me, and how much time are you giving me to review this? Tell them as much time as you want, but I have yet to have anyone go through it in less than an hour, and these are attorneys. So if it's going to take an attorney to spend an hour and go through it, I surely would expect someone to have a few hours on their hands and look at what is being said. Understand what is being said. Because this is your particular situation. You are unique. So again, this is the most concise information that is put out there for a homeowner. So please take the time to go through it. We're not going to go through everything today. I'm just showing you what we have in here. Okay, so as you go through it, the first 8 pages, again, it is the most meticulous information that are in there. You would spend an hour just going through these 8 pages, going back, going to the internet and looking it up. So if we've spent hours putting it together, I surely would expect that you take the time to just take it apart and understand what we're talking about. All right, so again, all of the information, the first 8 pages is very good. And it's, again, it's pertinent information. Understand what you're talking about. When you're talking about a conveyance, what is a conveyance? What's the difference between a conveyance and a sale? Consideration. Bet you didn't know that. So again, section 2, we're talking about the mortgage loan transaction history. Again, depending on your particular situation, you may or may not have anything like this. It just depends. That's all. So let's go to the next. Again, if you're an RMBS, we are going to have screenshots of our databases, whatever database we looked at to procure your information. And it tells you. Again, this one, there's group 1, there's group 2. So it just depends upon your particular situation. And this particular one, there are infographics. There's information that talks about the infographic. Again, in this one, this looked a little different than we had last time. And the reason is because in this one, we have MERS. All right, in this particular one, we've got purple lines. The purple lines represent the intangible obligation. So everywhere this intangible obligation went, that is what traveled. These numbers here, see paragraph 1 in the analysis. Well, that's information that's pertinent to your analysis. See paragraph 8. See paragraph 32. So there's a reason I'm putting paragraph numbers in there. I expect you to take it and look at it. Understand, because many of you out there have a better visual interpretation versus reading something and understanding it the first time. So this is to help you out. Okay, we then get into the actual analysis. We talk about the documents that we've looked at, and then we get into the examination. Again, depending on your particular situation, there can be 20 pages, there can be 40 pages. Anywhere from, 30 paragraphs to over 100 paragraphs. It just depends on the documentation that we have and that we are able to produce. So there is no set number. So again, we're just going to go through here. We talk about the trust. We talk about the closing dates. In this one, I'm actually giving you statutes. And here we're talking about Title 15, USC, Chapter 41, 1641G. All right? Again, read what this is saying, because your test is going to be real life. That is your test. In this particular one, we have Florida statutes. So I give you the statutes for your particular state. I'm talking about yours. If I'm in Florida, I give you Florida. If I'm in New York, all right, I give you New York's. And just so everyone is aware, New York is the only state out there who is not even remotely similar to any of the other ones, because they're using the 1961 codified version of the Uniform Commercial Code, while everybody else has a new and updated version. So where, for example, for Florida, they're going to use 3203 pertain to negotiable instruments. In Florida, they're going, or in New York, they're going to use 3202. And instead of A, B, C, and D, with A defining what is to be done and B, C, and D placing restrictions on how it is to be done, for New York, it's completely different. They just have 1, 2, and 3. So again, I've taken the time, I've gone through, and whatever I put in here is pertinent to you. So I would ask that you please read it. Again, we talked about UE ETA earlier. All right, look at what we're talking about here. 15 USC 96.1 73001. All right, I talk about UE ETA, but I talk about that UE ETA does not apply to the Uniform Commercial Code pursuant to this statute. So when they say, well, you know what, pursuant to the Uniform Electronic Transaction Act, we've got your electronic signature. No, it doesn't apply. Read this. I'm not going to go into detail because I want you to do the reading. When we talked about governing law, here it is, as stated on page 242. I'll tell you where I got the information. This is what it says. I then compare it to what New York trust law says. They said it's governed by New York. Here's what it says, state in New York. Okay, here's what New York says. So again, we talk about an assignment. We say it's invalid for this one. We then talk about what is valid. I tell you it's invalid, then I tell you what is valid. I back up everything that we say. So we give you the instrument number, who signed it, what title, all right, it was notarized, what date, by the person. This is as specific as anybody can get. There is no one out there that is being this specific. So again, depending on your specific transactions will determine on the arguments and the statutes that we're able to produce. So again, we're talking about the assignments and we go through this. In this particular one, we talk about conveyances, conveyance of mortgage loan. Well, Joe, where did you get that information? Well, as stated on page 95 of the pooling and servicing agreement dated January 1st, 2007 for the First Franklin Mortgage Loan Trust Series 2007-FF1 Trust. Well, that's where we got it from. Joe, what did it say? Well, this is a whole section. We're not going to read it. That's for you to do. Joe, you talk about closing dates. Yes, here it is. Here's the closing date. That's what we're talking about. We talked about prohibited transactions. Internal Revenue Code 860, just like I talked about. So I just ask that you go through it and take the time to read it, understand it. If you don't understand it, read it again. We are going to be having a webinar on MERS, Mortgage Electronic Registration Systems Incorporated. We're going to spend an hour just going on MERS so you have a better understanding. That is the next webinar. Why? Because it's very important. Again, the documents, I give you the document, MERS Procedural Manual. Joe, do you have it? Yes, we do. Here's a page where I pulled the information out. So everything that we state, we back up. When I look at your note, all right, I talk about the note, okay? It says here, this particular instance, the DOE note has been signed. By who? First Franklin, signed by Amy View as funder. The instructions preceding signature state, paid to the order of. Well, what does that mean? Well, then we give you the statute, then we tell you what the statute says. So again, I need you to understand exactly what it says. So, take the time, go through this. Understand. And here I'm talking about the DOE Mortgage. I'm talking about Covenant 16, governing law, severability, rules of construction. Quote, this security instrument shall be governed by federal law and the law of the jurisdiction in which the property is located. All rights and obligations contained in the security instrument are subject to any requirements and limitations of applicable law. Okay, so it's saying federal law and the law of the jurisdiction which property is located. Local law's jurisdiction. So I know where to look at. Again, I'm talking about specific paragraphs. Here, it was previously explained in paragraphs 31 to 60 how it is not possible for ownership of the DOE mortgage to have been assigned. So again, just go through it, take your time, enjoy this as if you have a glass of wine and you're going to sip it. You're not going to drink it like it's a shot. All right? This is a 200-year-old bottle of wine, so enjoy it. Here's section 4, applicable educational material. It may or may not apply to you depending on what the specific circumstances were of your loan. But we've gone through it just to give you some extra reading material. Information on endorsement, special endorsement, and then I've gone through and I've given you examples. I didn't make these up. We have a complete PowerPoint presentation on negotiable instruments, which we're going to have in the future. So with that being said, I'd like to conclude this webinar, and let's take this. Give me 1 second. Here we go. There we go. So, if you have any questions, I would encourage you to go to our website, or you can send us an email. You may email us at info@usequityinitiative.com. My name is Joe Esquivel. I am a licensed private investigator, and I welcome you for spending this time with me today. So with that, have a great evening, and I will talk to you soon.